You do everything right. You go to an in-network hospital, you verify your insurance coverage at the front desk, and you undergo your procedure. Then, weeks later, the mail arrives. You owe thousands of dollars. In the medical industry, this is called balance billing. It happens when a healthcare provider bills a patient for the difference between what they charge and what the patient's health insurance agrees to pay. Look at this flowchart to see how this operates. You go to a facility approved at your insurance. However, the specific specialists treating you, like an anesthesiologist or a pathologist, are often independent contractors operating outside of your network. They charge a premium rate, your insurance only covers the in-network base rate, and suddenly there is a massive financial gap. Because there is no contract between your insurance company and that specific doctor, the remaining balance bypasses your insurance completely. The specialist sends the bill directly to you. You are held legally liable for the cost of a doctor you never actually chose. I'm Marcus. I'm a patient rights educator, not a lawyer. For years, patients had almost no defense against this tactic, but recently a specific federal shield was put in place to stop this exact practice. This contract vacuum allows these charges to accumulate outside of your insurance coverage, but you now have a legal mechanism to intercept them before they drain your savings. That mechanism is the No Surprises Act. It is a federal law enforced by the Centers for Medicare and Medicaid Services, operating out of the Department of Health and Human Services. This relies on a legal concept known as the Supremacy Clause. If a state has weak consumer protections, this federal statute overrides them. It establishes a mandatory nationwide baseline that protects you in 3 specific scenarios. First, emergency services. If you are rushed to the emergency room, you cannot be charged more than your standard in-network copay or deductible. This applies even if the hospital itself is completely out of network. Second, non-emergency care at in-network facilities. If you schedule a surgery at your approved hospital, those invisible out-of-network specialists we looked at earlier are legally barred from sending you a balance bill. Third, air ambulances. If you require emergency medical transport by helicopter or airplane, the law bans those notoriously astronomical out-of-network flight bills. This legislation removes the patient from the middle of a billing dispute. It forces the insurance companies and the medical providers to negotiate the costs amongst themselves. However, this shield has specific blind spots. For instance, ground ambulances are completely excluded from federal No Surprises Act protections. If you take a ride in a standard ambulance, you can still receive a massive out-of-network medical bill. Another major exception is voluntary consent. Providers can sometimes hand you a notice and consent form before treating you. If you sign on that dotted line, you legally waive your federal protections and agree to pay the higher out-of-network rates. Blind trust and rapid signatures at the check-in desk will leave you vulnerable. The federal shield is powerful, but it requires you to actively guard your rights. When an unexpected bill arrives, do not pay it immediately out of fear. Wait for your insurance company to send your explanation of benefits, or EOB. In this comparison, if the hospital bill demands thousands, but your EOB responsibility is $50, that's a balance bill. Next, check the EOB line items. Was it an emergency? Was the hospital in network? If yes, you have grounds to fight. Then, pick up the phone. Call your insurance provider and explicitly ask them to verify if the No Surprises Act applies to this exact claim. Get their confirmation on the record. If you are uninsured or paying entirely out of pocket, you rely on a different protection called the good faith estimate. Providers must give you an upfront cost estimate. If your final bill exceeds that estimate by $400 or more, you have the legal right to dispute it. Information is leverage. Gathering this specific documentation transitions you from a helpless target into an active auditor of your own healthcare. With your documents in hand, call the medical provider's billing department. You must use this exact phrasing. I believe this may be an illegal balance bill under the No Surprises Act. While you are on the phone, demand a fully itemized bill. Forcing the provider to justify every single charge often reveals outright administrative errors or upcoding, which is when a facility bills for a more expensive service than you actually received. If the provider refuses to drop the bill, you escalate. File an official complaint with the federal CMS No Surprises Help Desk or your state's Department of Insurance. These agencies have the authority to investigate and penalize providers who break the law. Even if your specific situation isn't covered by the law, you still have a backup plan. Most nonprofit hospitals are legally required to offer financial assistance or charity care programs, which can drastically reduce your debt if you apply. Treat an unexpected medical bill as an opening bid. By utilizing these specific federal rights and defensive steps, you ensure you can successfully push back and protect your financial survival.